Welcome to Beyond the Handbook, where we talk about what really happens after HR policies meet real life. I'm Chris Scott. I'm a partner at Thomas & Hafer, and I'm also the chair of the Employment Law Group. This show is for anyone who's ever looked at an employee handbook and thought, that's nice, but what do we actually do now? It's also for people who realize that most of the employees that they look after signed the handbook but probably never read it. Well, we're here because compliance doesn't stop at the bullet points. Real situations are messy. The law is constantly changing. Administrations change, people say one thing and mean another, and HR is stuck in the middle. HR is always trying to make it work without breaking a dozen laws before lunch. That's where I can step in. I'm hoping that this podcast will, over the next weeks and months, will help you get a little bit more surety in what you're doing in your profession. In each episode, we'll take one issue, something every employer deals with, and go beyond the handbook. We'll talk about what the law really says, what it doesn't say, and how to keep your workplace fair, compliant, and hopefully just a little bit saner. This podcast is brought to you by Thomas & Hafer, LLP. It's for informational and educational purposes only. Nothing discussed should be taken as legal advice. Listening to this podcast does not create an attorney-client relationship. Laws vary by state, so please consult your own counsel for advice specific to your situation. Today's episode is the interactive process, that mysterious conversation the ADA expects employers to have with the employees when they say, "My back hurts." The problem? Well, most of our policies, at least as I've seen them, simply say we'll comply with the applicable law. That's HR speak for we'll figure it out when it happens. Well, today we're going to figure it out together. We'll break down the process, what it actually looks like, how to document it, and the top 3 mistakes that can trip up even the best HR individuals. At the end, I'll give you a free 1-page interactive process flowchart, and you can use it with your team tomorrow. So, let's go beyond the handbook. Okay, basic number 1. What exactly is the interactive process? Well, in theory, it's simple. When an employee says they have a medical limitation that impacts their ability to do their job, the employer is then beholden to have a conversation. One that's interactive, not just talking at the employee, but that interactive process is to determine whether there is a reasonable accommodation that would allow that employee to continue doing their job, and most importantly, the essential functions of their job. In practice, it's anything but simple. Because the ADA doesn't hand you a checklist. It doesn't say, step 1, send in this form, step 2, talk to the doctor. It simply says you have to engage in good faith. And that good faith is usually where things go off the rail. Now, the goal here is not perfection. You're not expected to be a medical expert. You're not expected to have every answer on the spot. But the law genuinely wants to see that you tried, that you took the request seriously, you asked questions, you explored options with the individual, and you didn't just hide behind policy or push the problem back to the employee. If you can document that effort, and we'll talk about that in a little bit, you're already doing better than half of the employers who end up in litigation. Here's the thing that most people miss. The interactive process is a conversation. It's not a form. The form is something you do afterwards. It's dialogue. It's not a piece of paper that you file. It's dialogue. I'll keep saying that. It's dialogue. You can absolutely use letters and medical certifications, and you should. But the real point is to show that you listened, you asked questions, and you responded thoughtfully. And that starts from the moment you knew or should have known that the employee might need help. Not just when they use magic words. Reasonable accommodation doesn't need to be in the vernacular of the employee. But it starts from the moment that someone says, "I'm struggling with my shoulder," or "I'm having trouble with my medication," or "My doctor says I shouldn't lift heavy boxes." That's your cue to start the conversation. The courts have been very clear. You can't play dumb. You can't pretend that you didn't understand what they meant. Once you're on notice, you're on the hook to engage. Kind of like what I tell my clients. The interactive process can never be a legal ostrich. You don't win by pretending you didn't see the accommodation request or by putting your head in the sand. That's the foundation. It's a conversation. It's not paperwork. But after the fact, it needs to be documented like it's paperwork because that's going to save your bacon in court. In the next segment, we're going to walk through exactly what it looks like step by step. What to ask, how to avoid the traps, and how to avoid turning a well-meaning HR conversation into an ADA violation. So let's turn to that idea of the conversation. Let's turn it into something that we can actually follow. Because let's face it, when somebody says we need to engage in the interactive process, most people's first instinct is to go to Google and figure out what that interactive process is, or whether there's a template that can be used. Maybe pray that SHRM has one that they can download. Let's simplify it. Here are 5 steps that you can use almost every time. Step 1 is notice. We talked about that, but it starts at the moment you knew or should have known that the employee might need accommodation. It does not have to be a formal request. You don't need a letter from a doctor. Sometimes it's just an offhand comment. I'm having trouble standing all day. Something like that. That's your signal. You don't need to solve it right away, but you do need to start paying attention. Now that you're on notice, you can't claim ignorance later. That defense died with the fax machines. Step 2, gather your information. Here's where you get enough information to understand the limitation. You can ask for documentation. You don't have to ask for a diagnosis, but you want to focus on function, not diagnosis. You don't need to know whether it's a herniated disc, sports hernia, sciatic nerve issue, rotator cuff. You just need to know at this point what they can and cannot do. And for the record, you can ask questions. HR sometimes acts like the ADA stands for avoid discussing anything. It doesn't. You are certainly allowed to clarify what tasks are affected and how you can be of help. Step 3, discuss. This is that interactive part we've been talking about. Pay attention to this one. You, the employee, and perhaps a supervisor needs to sit down. Zoom, in person, anything like that. Talk through the job duties that are being affected and what could help. It's okay to throw out, let's see what might work if you're not sure. You don't have to agree to every request. That's where the undue hardship comes in. But you do have to explore all of the options. Here's the pro tip. If you do nothing else, if nothing else comes out of that conversation, document that the conversation happened. Write down what was said, what was offered, what was rejected, what you agreed to revisit. That note can again come back and save you if you get into litigation. Step 4, now that you've had that conversation, take the time to evaluate. Take that information and figure out what's reasonable and what is an undue hardship. That means allowing the employee to do the essential functions without imposing an undue hardship. And what is that undue hardship? It means that you don't have to create a brand new position, but you can't just dismiss ideas because they're inconvenient. Here's the rule of thumb that I would like to give to you, that I give to my employers that I counsel. If you do it for your star employee without blinking, it's probably reasonable. Step 5, decide and document. You, ownership, management, make a decision with the assistance of the employee. Yes, no, modified. Confirm it in writing, whatever that is. Just a short confirmation. We met on October 6, 2025. We discussed your limitations and agreed to sitting and standing as needed, starting on November 7th of 2025. And we'll review it in 30 days to determine how it's working. That's it. Short, clear, gives you that confirmation that you actually did the process. And again, document that it occurred, document exactly what was decided. Here's the kicker. The ADA doesn't penalize you for trying. It penalizes you for ignoring. Even if you can't accommodate every request, the fact that you engaged and documented is the best defense. Remember the 5 steps. Here's the mantra. Notice, gather, discuss, evaluate, decide. That is your 5-step roadmap. Okay, so now that we've talked about the 5 steps, let's talk what separates good employers from great employers, and also where good employers go wrong. Because the interactive process isn't complicated, but it is fragile. It can fall apart when communication stops, and when people think it's a once-and-done process. Here's the first mistake, treating it like a paperwork exercise. I see this constantly. HR sends a form, gets a doctor's note back, checks the box, moves on. That's not a process, that's a transaction. The ADA expects dialogue, not just data entry. If you never actually talk to the employee, you've missed the interactive part entirely. When that happens, the plaintiff's lawyer will have a field day quoting the word interactive back to you at your deposition. The fix is easy. Talk first, form later. Mistake number 2, handing it off to the supervisor and hoping for the best. This one is pretty brutal. HR figures, well, they know the job best, they can handle it. Except that the supervisor doesn't really understand what ADA means. They just want to get production back on track. I've seen more than one lawsuit start with a well-meaning comment like, well, if you can't do the job, then this is not the right place for you. Intent doesn't matter. Once that's said, you're looking at a pretty significant lawsuit and money out of the company. Here's the fix. HR needs to stay constantly in the loop, always guiding the conversation, reviewing options, making sure the tone stays collaborative. Bring in the supervisor, but don't let them lead the way. Mistake number 3, failing to close the loop. This is the one that trips up even careful employers. Everyone has the initial conversation and maybe even agrees on an accommodation, and then there's silence. No follow-up, no check-in, no documentation that it worked or didn't. Let's use a real-world example that I've seen. Say you've got an employee on the desk job that develops venous thrombosis. Through a very protracted but collaborative interactive process, we got the employee one of those under-desk recumbent bicycles, a little pedal device that fits under the workstation. It was a simple fix. Cost $100 on Amazon. We did that. We sent a quick confirmation email. But here's where the good employer on the front end got burned on the back end. Lack of follow-up. Flash forward 6 months, the employee's manager complained that the pedaling is getting distracting. IT moves the desk during renovations and the bike disappears conveniently. The employee's condition flares back up, they go back out on leave, and now you've got a retaliation and a failure to accommodate claim brewing in the background. The entire mess started because no one closed the loop. The fix? When you grant an accommodation, whether it's a monitor riser, modified schedule, or that under-desk bike, schedule a follow-up for 30 days. Even if it's just a short email. Hey, checking in. Is the setup still working for you? That one line shows that you're engaged and that you didn't just toss a gadget at the problem and walk away. It's easy to treat the process like a box to check. Good employers, specifically the ones who avoid lawsuits and keep good people, treat it like an ongoing partnership. That's the difference between compliance and credibility. Well, we've come to the end of our time. So if you remember nothing else from today, please remember this. The interactive process is not about perfection. It's about participation. Start that conversation, follow through, and then document it. Because at the end of the day, the ADA does not expect you to perform miracles. It just expects you not to ghost your employees. But if you're going to ghost them, do it after you've sent the accommodation confirmation email. If you'd like a copy of today's Tool of the Week, which is our one-page interactive process flowchart, please just reach out to me or anyone at Thomas Hafer. My email is cscott@tthlaw.com. Please make sure to join me next time when we go beyond the handbook again. Next time, we'll be talking about effective disciplinary policies, how to use them as both a sword and a shield for your business. Thank you again. I'm Chris Scott. This has been Beyond the Handbook, where policy ends and the real work begins.